Good afternoon. For all of us following or perhaps not following the news, SEBI's story has become a part of almost daily excitement. It's not for the first time that Hindenburg's analysis has reached the Indian markets, but this was the first time that India's apex financial market regulatory body, SEBI, has been a target of how do I put it, of an attack perhaps, or at the very least concern. The investigation has opened up a Pandora's box of documents and trades. Possible leadership failure at SEBI begs the questions: how good is SEBI in tackling insider trading? And if SEBI has historically been consistent with their adherence to the rule of law. Now, today's conversation is not about this, but it's about a larger issue, and that Renuka and her team's work at TrustBridge Foundation looks at, where they have analyzed SEBI's orders on insider trading matters for over a 20-year period. The paper that they have come out with evaluates how these orders have fared at the SAT, the appeal rates, and the modifications thereof. Their work makes some suggestions grounded in legal theory and how SEBI could improve its order writing process. So it's not really about the current excitement. So just a clarification that you asked me to put up front. Let me just give you a background on this, of why is this issue also of interest to us at CSEP. This work is very innovative in the sense it uses some of the latest technologies, including those of AI, to try and understand how can we process large amounts of data in limited time, when with limited resources, and be able to come up with credible, robust analysis of issues which are otherwise very difficult to fathom. So welcome, Renuka. I'm so glad that you could be here. I'm also pleased to welcome our two panelists, distinguished fellow Ambassador Dr. Jaimini Bhagwati and Dr. Janak Raj, our senior fellow. Dr. Janak Raj is a senior fellow at CSEP, where he heads the macroeconomic segment of the growth, finance, and development vertical. He works specifically on fiscal federalism in the health sector, climate finance, and multilateral development banks. This is as of today. It may change tomorrow, as I think every few months his range has been expanding at CSEP. Dr. Raj is also currently a member at the JM Financial Center for Financial Research at IIM Udaipur. He has nearly 4 decades of experience with the RBI, the IMF, and the many other things. It's a much longer list of things. So, but I'm going to shorten that and also say that he has served as the RBI nominee director at the governing board of the BSE, and therefore has deep interest in these specific topics as well, and as a senior consultant in the Department of Financial Services, Ministry of Finance. Ambassador Jaimini Bhagwati is a former IFS officer and a financial sector and derivatives specialist. He was appointed as India's High Commissioner to the United Kingdom in 2011. Immediately prior to this appointment, he was India's ambassador to the European Union, Belgium, and Luxembourg. Earlier, he was an additional secretary in the Ministry of External Affairs, and prior to that, as a joint secretary, capital markets and pension reforms in the Ministry of Finance. He was employed for 11 years at the World Bank Treasury in Washington, D.C. in 2 phases between 1991 and 2005. And his responsibilities included issuance of World Bank bonds, pricing of associated derivatives transactions. After retiring from the government of India, Dr. Bhagwati has joined CSEP as a distinguished fellow, which is probably your most important position. And he was also the Reserve Bank of India chair professor at ICRIER from 2014 to 2018. Thank you and welcome.
Thank you.
So, Renuka, may I now request you bring on the slides?
The small fireworks. Good afternoon, everybody. And Lavish, thank you very much for having us here. This is the first. Let me see. Yeah, this is the first time that actually we are presenting this work outside. And so we would really appreciate your comments on both what you think of it, how you see it, and how we could potentially improve this work going forward. I'd also like to introduce 3 of my colleagues from this list who are here. There's Natasha, Sonam, and Bhavin, who have been able authors in this endeavor. So let me begin by kind of saying, why insider trading? So we got interested in the question of insider trading because we saw that there is, an increase in investigations or increase in the salience of insider trading at SEBI. It has become a burning issue. SEBI and, generally the media is sort of talking about it as if it's a big blot on the Indian markets and there's something major going on, and maybe there is and maybe there isn't, right? So that's not what we are after. This is just to say that this is an issue that has become important for the regulator. And the regulator has also made significant investments in its infrastructure in trying to figure out who could potentially be an insider. So they've got this software that does alerts on what might potentially be an insider trade. They have, for example, also been asking for access to phone records because it's an important part of figuring out who's an insider and who is not. So clearly, it's an issue on the regulator's mind. And what that made us think was that if there is something that is so important to the regulator, it is equally important to us as citizens and as potentially regulated entities to see how is it that the regulator itself is performing its job. Because there is a rule of law framework that governs how regulators should behave. This includes how they should write law, but also includes how they should enforce the law that they write. And can we evaluate the performance of the regulator on how it's performing its quasi-judicial function? So that is really the motivation for why we began this. So we have three main questions that we are trying to answer in this exercise. The first is just, what are the statistics regarding SEBI's enforcement actions against insider trading? The truth is that we don't know, because the annual report does give us some numbers, but it doesn't give us a full picture of what kind of insider trading offenses is it going after, what kind of insiders is it going after, what is insider trading increasingly, because that depends on the definition of insider trading, how many cases does it see and how many orders does it eventually pass, what kind of penalties does it pass something else more than penalties like disgorgement, debarment, what are the amounts, is there a correlation in the amounts and the kind of offenses that you see? All of this data is just not available anywhere. The annual report does not give us these statistics. And actually, this data is embedded in the orders that SEBI passes. So you actually have to read the order and see, how many people were there, what kind of sanctions did they get, what kind of offenses were they said to have committed. And so this data is not available. So one of our first contributions really is to put together a data set so that we can study what is going on in enforcement and at SEBI. The second question that we ask is, okay, so you've got this data set, you've got all these metrics of what SEBI is doing on insider trading. Is what it is doing in its enforcement action consistent with the rule of law? And how do we define rule of law? We say, there are procedural and substantive rule of law requirements, and I'll come and explain what we mean by procedural and substantive. So we design some metrics grounded in the law itself. So there is a SEBI Act. The SEBI Act requires SEBI to behave in certain ways. There are regulations. They require SEBI to behave in certain ways. There are Supreme Court decisions. They require SEBI to behave in certain ways. And then there is just the theory of, administrative law that requires any regulated entity to behave in certain ways. So we put these together and we have what are procedural rule of law indicators and substantive rule of law requirements. And we say, does SEBI match up to them? Right? And then finally, again, this is not available anywhere. How do these orders perform at SAT? So this information is also not available anywhere because you kind of see broad aggregate statistics of appeal rate and overturn rate at SAT, but you don't know issue-wise. How is it that SEBI is faring on these questions? And while we've done this work on SEBI, I'll just digress a little bit and say that this is part of our larger work on analyzing regulators. We are doing this with electricity regulators, and in fact, we have done this for some 7-8 states and the performance of ERCs at APTEL. We are planning to start this effort on the RBI as well, though the RBI does not publish orders, it only gives us press releases. So in some ways, it's even worse because you don't don't even know what the regulator has done. Having said that, whatever information that we can pull out from public documents, our aim is to bring out a framework for analysis of regulators, and we want to be constructive while we do it. So sure, if things are broken, then how can we fix them? Because we don't want to be adversarial here. We want to say, we understand that there are these gaps. Can we think a little deeper about what drives these gaps and how might we fix them? So, that's the spirit with which we are approaching all of this work. So let me quickly go through the SEBI framework. SEBI was established in 1992 under the SEBI Act, and specifically in relation to insider trading. Section 11 empowers SEBI to prohibit insider trading. 12A prohibits any person from engaging in insider trading. 11.4 empowers SEBI to impose sanctions such as debarment and restraint through a reasoned order. Section 15G prescribes floors and caps for what a penalty amount should be. And finally, 15J, which is kind of important to us because it lays out how SEBI should arrive at a penalty amount. Because ultimately, the penalty can't just be something that the regulator feels like it or feels is appropriate. It should really be based on certain considerations of how you arrive at a penalty amount. And 15J clearly states that it has to, be proportionate to the amount that you have gained unfairly or the loss that you have avoided. Have you caused? What is the loss that you may have caused to a group of investors? And is this default repetitive in nature? Right. So these are the considerations that SEBI has to put before it arrives at a penalty amount, and this is something that we focus on quite a bit. And as we go forward, you will see in our data. And then there are regulations where these also become important for our thinking on what are rule of law measures, because if the regulation describes an insider in a specific way, then the order has to reflect that the insider is actually specified in the way that the law says somebody is an insider, right? So the regulation 2G defines an insider as a connected person or in possession of access to UPSI, also as a deemed to be connected person. Then there is a definition of UPSI, which is unpublished price sensitive information. Then there is how you communicated or procured this unpublished price sensitive information, and then you are an insider and you committed insider trading. Of course, if you traded given the UPSI, which is the unlawful trading in securities. And then you could be an insider and have violated the law because you did not undertake certain disclosures that were asked of you under the PIT code and under some code of conduct violation. So it's important to figure out what that structure is, and that leads us to the definition of who's an insider and what is insider trading. Then there are, of course, SEBI decisions by the adjudicating officers and full-time members on the SEBI website. Then there is the Supreme Court decision that we also look at, which talks about, this 15J question that I talked about, and how else could you determine penalty if not 15J? So the Supreme Court lays out certain guidelines for determination of penalties, and I'll come to it again when we are discussing the data. So this, yeah. So, but we did not find any publicly available information on enforcement manuals, guidance on how orders should be written, guidance on choice and quantum or duration of sanctions, guidance on interest rates, and similarly guidance on determining extent of gain or loss caused, right? Because if amount gain or loss avoided is such an important component of what goes to determine a penalty, is there any publicly available guidance on how this should be calculated? Maybe SEBI has this, but we don't see it on their website. There was a Dave committee report that went into this issue of how you should calculate these things, but its recommendations have not been implemented yet. So because we didn't find any of these things, we cannot rely on these to develop our metrics. And we'll come back to the point of not finding these kinds of manuals and guidelines, because perhaps they shape how the regulator behaves if they don't exist, right? So with this framework, we come to the measures of rule of law. Like I said, we have procedural measures and we have substantive measures. In the procedural measures, these are like simple measures just based on the principles of natural justice. For example, you need to establish fair, time-bound procedures, and this requires that certain information should be part of the order. So whenever you read an order, you should find the following pieces of information in the order, right? For example, what was the date of show cause notice? What is the period of investigation? What is the period of the unpublished price sensitive information that you are looking at? And what is the time period for the payment of penalty? Like some basic facts about the case that should be part of the order. And that is what we go and we read each order to see if these pieces of information are present or not. Then we say, okay, now we go on to the substantive rule of law indicators. These are requirements based on the SEBI Act and PIT regulations that I just described. And these are very important to establish legitimacy of regulatory decisions under applicable law. So what would these include, right? So what are the principles here that we test against? So one, that if there is a violation, then it must be based on identification of ingredients of the violation set out in the law. All sanctions must be based on a clear violation and a clear establishment of the insider relationship. So SEBI order should specify in what manner is somebody an insider. In what manner has the offense of insider trading been committed? The sanction and quantum of sanctions should be based on factors mentioned in 15J, as I just described. And when they are not based on 15J, they should be clearly stated and should be specific to the case. Again, this is coming from the Supreme Court judgment, which said that you need not, 15J is not exhaustive, but if there are other factors, then they should be specific to the case. They should not be general, like, oh, it affects market sentiment. That's not specific enough to a particular case. And so that's what we go and test on every single order. So all this is nice and easy to say, but how do you actually get the data? And really, I think, very often, certainly in economics, the bulk of the work, and my fellow economists will commiserate, the bulk of the work is putting the data together. And then you can run your regression and it's fine. But the maximum amount of work has just been trying to get the data and clean the data. And so it is true when we do law and economics work as well. So what did we do? We got all the orders on the SEBI website from September 2003 to July 2023. We got from that list of orders, we did keyword matches. So if the word insider, if the word prevention of insider trading, if the word unpublished price sensitive information occurs in the text of that order, then we will read that order at least once. So that was the condition that we put out. And so we got 333 orders based on these keyword searches. Now, every order may have multiple people, right? So there is one order, but it has 5 people in that order. So, and each person in that order might have committed a different offense and might get a different sanction. So we treat each person in an order as a case, and the case is our unit of analysis and not the order. We created 56 rule of law indicators based on the framework that I just described, and the SEBI case. The cases were read by a team of lawyers, and the findings were recorded only on explicit statements. And here are 2 caveats here. Again, one, that the statement has to be explicit. If it is unclear, we give SEBI the benefit of the doubt. And second, we pass no judgment on the quality of SEBI's judgment because we can't. Right? So we are not the investigating officers. We actually don't know all the facts of the case. So whether you have classified someone as an insider correctly or incorrectly is not something we can judge. But whether you have at least classified and specified that this person is an insider is something that we can judge. So these are our 2 caveats. So there is no judgment of the quality of SEBI's thinking in that way in this exercise. So one is explicit statement, and the other is that we are just going with what is written in the order and not whether what is written is, thoughtfully done or not done. At least it should be written in the order. So in some sense, it's a very low bar that you should expect regulators to live up to. And then, yeah.
So you are certain that all the orders were based on the website? It's not that only one class of orders are
No,
based on.
no. So all the orders that are, if now there are some orders that SEBI has not placed on the website, then we cannot know. But we've got the bulk of the orders in these years, and we are able to find all the insider trading orders. So yes, I mean, if you ask me 100%, do I know that we have captured all insider trading orders? The answer is no, because if SEBI has not put it up, then we haven't captured it.
And there's no way to cross-check the 300 and whatever, over the 20 year.
No. And then these findings were reviewed through multiple error checks. So one team read a set of orders, then the next team read the set of same orders, and then we checked whether what they have recorded as data is correct. If there was any inconsistency, then we go back and read those orders, and we spent a lot of time cleaning this up and going through multiple error checks. And then we said, look, this is unsustainable. And we need a technology solution to this, because if we want to do this at scale, then we can't be manually reading these orders. And of course, when people read the orders, there are chances of inconsistencies in the way you read a statement and in the way I read a statement. And Bhavin is going to do a talk tomorrow, for those of you interested, a much more detailed talk on how we deployed large language models to get this data set. Today, I'll just kind of very briefly explain what we did. So we got all the orders from the SAT website. We did a similar keyword search there. And I'll just come back to the mapping between SEBI and SAT in the next slide. I'll just kind of tell you here that, what we did with LLM. So once we got these orders, we trained the LLMs and we did the prompt engineering to extract the data from the orders and create a CSV file, which has all the answers. And then we again ran checks. We ran two main types of checks. One is a logical error and one is a flag for review error. So there, for example, we said, if you can't have a yes on appeal allowed and appeal dismissed, because then that's inconsistent, it's illogical. And so wherever we found these kinds of errors, we went back and read it manually and corrected it. And similarly, flag for review error, if the appeal has been fully allowed, then the indicator on sanctions modified, for example, should be a yes. So we had all of these, we had multiple error checks like this written down, statements where for every indicator, if one thing is yes, then two other things cannot be no. Or if one thing is no, then three other things cannot be a yes. And so we went through these data checks again and again with the SAT data set as well. And so we brought the SEBI data set and the SAT data set together. And believe me, this was the hardest thing to do, much harder than reading the SEBI orders manually, because there's just no way to tell. Yeah.
Sorry. So when you were coding the orders into data.
Yeah.
And you were verifying. So you did the internal checks, which you have outlined.
Yeah.
Did you also do manual checks?
Yes, afterwards.
And was there there a format that you manually looked into some orders?
Yes.
And you.
Yes. So in fact, before we did the LLMs also, before we trained the LLMs, first we read a bunch of orders manually, because on the basis of that.
And so that you validated.
Yes, we validated that, absolutely.
So what are the clarification? So you said they got these orders from 2007, but the regulations was issued only 2015. So they were issuing orders.
WTMs, but.
There was an older set of 1992 regulations that were replaced in 2015.
Okay, so the orders for 2015 were based on those.
Yes.
And was there a big difference between those two sets of regulations? So the orders will also be different in terms of nature. Okay.
But some of the indicators, like the procedural rule of law indicators or 15J, we've kind of taken care to focus on what is largely consistent across this time period. So the mapping was the hardest thing that we did, because there is, if you go on the SAT website or on the SEBI website, there is no way to tell where, which order is referring to which SEBI order. So again, what we had to do was we again did a text search in the PDFs, where we said, we look for three things: the party names, both in the SEBI order and the SAT order, the company name, both in the SEBI and the SAT order, and the date and number of the impugned order. So once we find a match, then we were able to map them. And of course, then you have to manually look and see if it relates to the same order. But we got 201 mapped instances of SEBI to SAT. And again, here our data set is not complete, because the relatively new cases that are now appealed and whose order is not on the SAT website, we do not know. Right? So there might be some cases that are still going on. And so whenever we see SEBI's appeal rate, we should keep in mind that, the more recent years are probably not in there, because those cases have not been completed. Orders are not on the SAT website. And SEBI, of course, doesn't tell us of the, 100 orders that it might pass in a year, how many of them have been appealed and what the status is. You just don't get that information. Yeah. Yeah. They were not appealed, most likely. Yes, yes. Our assumption is that they were not appealed. They could have been settled, but again, we don't know that. So we are going again, we are giving benefit of the doubt and saying that we think that they were not appealed if they don't make it to the SAT. So this is a lower threshold, right? The appeal rate could only be higher than this if we have missed certain appeals.
Is this 201 is the number of total cases? Or
The cases, the people, right?
So,
It's the, yeah.
it also contains 5 cases.
We have 5. Yeah.
So this 201 refers to that.
Yes,
unit.
because sometimes of the 5 people, only 3 might appeal, 2 might not appeal, right? So that becomes again problematic. Yeah. All right. So now comes the story, right? This is all kind of getting to our results. So what are the statistics regarding SEBI's enforcement actions against insider trading? So we had 333 unique orders and we have 902 cases. So basically, number of people in each orders. And you see that an adjudicating officer has approximately 2 alleged violators per order, whereas a WTM has about 4 to 5 alleged violators per order. And out of 598 violators in the case of AOs, 336 have a sanction, which means that SEBI is not sanctioning every order that it sees. Okay, and that's we don't know what to make of it. I'll come to it in the next slide. And similarly for AOs, it's 229 over 314. And if you look at the trend, and this reflects what we see in the news about SEBI's sort of increased importance given to insider trading. It may be that other orders, overall SEBI enforcement has increased, right? But we don't look at that. We are only focused on insider trading cases. And so we see that the number of orders has really shot up since 2019. Because it is clearly great interest on insider trading. So again, what are the kinds of sanctions we see? So the law says that the AOs can only impose penalties, whereas WTMs can impose penalties, disgorgement, debarment, restraint from capital market. And so in our data that is reflected, we see that 62% of the cases, there is a sanction. For AOs, 56% of the cases, and for WTM, 73% of the cases. Full-time member. Okay. Now, again, it's difficult to figure out what to make of this 56 or 73. One would say that, if you're not putting a sanction against everybody, then are these frivolous cases that you're bringing to court? Alternatively, you could say this is a very high rate, which means that, more than 50% of the cases that are coming, you are passing an order. So it's very difficult to pass a judgment on what to make of this 56 and 73% number. So, it is what it is. And 46% of the cases a penalty was imposed, and the 3 main sanctions really are penalty, disgorgement, and debarment from capital markets. So that's what you see as punishment by SEBI. If you look at the sanctions on statistics, you see that there is a big skew. So the average penalty is very high, but the median is actually only about 8 lakh and 15 lakh for AO and WTM respectively. So what this really means is that there are some cases that become supremely important that kind of catch media attention, and you see these big numbers. For example, Satyam is part of our data set, right? So you see that there are these big numbers that get imposed, but on an average, I think the minimum threshold for the penalty is about 10 lakh, and we think that SEBI is pretty much doing the minimum threshold more often than not, which is why you see the average what it is. Similarly, in disgorgement, you see a big skew. The average is very high, whereas the median is low. And for debarments, on an average, SEBI debars people from capital markets for 3 years. And, we have a separate article that we wrote a few months back on how SEBI is imposing debarment and what are the reasons it's giving. And we think that there are huge problems in the way it's imposing debarment, because it means that for 3 years, you can't trade in the capital markets. And that's a big cost. Sometimes maybe it's more expensive than a penalty imposition. And there is really no guidance in the law that tells SEBI on how it can impose debarment. But anyway, so this is the same thing in a prettier picture. Then what we also find is that there are,
How far back are you going? Right up to 1992?
no, 2003. Yes. Yeah. Okay. Yeah. At least one side. So basically, we also find that when it comes to whole-time members, you do see them giving multiple sanctions at the same time. So if I'm already imposing a penalty on you, I'm also imposing a debarment and a disgorgement. Or if I'm already imposing a debarment, I also impose a disgorgement on you. So there are quite a few instances of multiple penalties. And this is a question on our mind as to what drives multiple imposition, and then does the number change, right? Because if I'm putting two sanctions on you, what is it that ultimately the overall impact on the person is. Then we create a variable called monetary outflow, which is the sum total of penalty and disgorgement if there is. And we see that actually, if you have, for example, all offenses, if you have been guilty of all offenses, then the average monetary outflow is some 43 lakh. But when I say none, it means no explicit mention of the violation. And you see that that has gone into crores. So there is a little bit of a mismatch here on the number of offenses that we see and the average monetary outflow that is being imposed on people. Right. So this is just a overall summary. You see that cases are going up. You see that almost more than 50% of the cases for AOs and 70% for WTMs do result in a sanction. We see that WTMs often impose multiple sanctions, and we see that there is a skew, that there is an average penalty which is much higher, but the median penalty is much lower, which means for most of the cases, the penalty is closer to the minimum threshold. Right. So how does SEBI fare on procedural rule of law measures? What we find here again is that 7.1% looks very small, but it's as trivial a matter as date of show cause notice not being mentioned. And this can be very easily resolved, right? Similarly, the period of investigation not mentioned, the period of UPSI not mentioned. You have 1/4 of cases where this data is just not mentioned clearly in the order. There is no description of UPSI in 20% of the cases. When it comes to looking at precedents, SEBI does really badly. Almost 87% of the cases do not cite any previous AO or WTM order. And that's problematic from a rule of law perspective, right? Because you want to build on what that people previously have said, and then you want to build a narrative or a view for the regulated entities also, that the regulator is behaving in a consistent manner because it's citing precedents, but we don't find that. Then similarly, in 63% of the cases, we find that penalty ordered, but interest rate was just not specified. In multiple cases, we find that the time period for payment is not specified. And again, like I said, these are very basic things that we could very easily fix in the quality of the orders. So now I come to substantive rule of law measures. So as I had said, right, what is an insider? We want to ask whether SEBI clearly specifies the insider relationship in the orders. So an insider is a connected person or a deemed to be connected person or has access to UPSI. And this access to UPSI is problematic in and of itself in terms of just how does having access to UPSI make you an insider, but we are not getting into the policy question of how you define insiders. For this paper, we are just going into what an insider is. And so we find that, we ask a simple question. Is the connection clearly specified in the orders? And you find that in 230 of these cases, the connection is not specified. Now that's pretty large, right? That if you are accused of being an insider and there is a penalty imposed on you, and sorry, from here on, we only look at those cases where a sanction is imposed, because if a sanction is not imposed, it's fine, right? So we look at where a sanction is imposed. Did SEBI clearly specify connection? And we find that in many cases it didn't. Then we want to give SEBI the benefit of the doubt and say, if you have at least sort of described it, then we will say, okay, fine, you've at least said something about the connection. And that's 86% of the cases again. So, that means that 14% of the cases, even that much is not done. And so we think that there is a problem. And again, what you see here is that the number of people who have access to UPSI is the one that is increasing. So people who are convicted of insider trading are increasingly those people who have access to UPSI. That is a much harder thing to establish, or in some ways much easier for the regulator to say you have access to UPSI or you're deemed to be connected, than to actually establish the clear connection, which might make you an insider. And this is more, I think, of if I may use the word fault, of the regulations, which are kind of vague on who all can be cast as an insider. And that gets reflected here, and that potentially gets reflected in the overall statistics you see. Because, if access to UPSI, and this has been on the books for a while, so it's not new, but clearly it is now used a lot more to carry out these investigations. Fine. So what is insider trading? Either you have to have unlawfully traded in securities, you have to have communicated UPSI, non-compliance of PIT, and non-compliance of other PIT. So we basically categorize these as three broad things. We combined, did not comply with PIT regulations later, but here you see that the most common violation is really unlawfully trading in securities, and then we sort of try and focus on that. So if you actually trading in securities, when you should not, you're trading in securities based on the information that you have. So I could just have information and do nothing with it. I could just communicate it to you, or I could trade myself. Then we look at 15J and we say, all right, in how many cases are the ingredients of a penalty present? And we find that basically no penalty ingredient is present in 58% of the cases. So where there is no mention of amount gain loss avoided, there is no mention of how much loss to investors. In fact, WTMs are increasingly saying that it's impossible to find out the overall loss to investors because it is hard. And you see that 155 cases, you see that the AOs are actually saying this is not quantifiable, and the default is sort of not doesn't occur that much in the orders. But what is really alarming to us is that in 58% of the cases, there is no penalty ingredient that is mentioned. And so then you say, okay, fine, let me look at those cases where there is no penalty ingredient, but what is the proportion of cases where a penalty is still imposed? So you see in the case of AOs, in 68% of the cases where a penalty was imposed, there was no penalty ingredient in that order. Similarly, in 1/4 of the cases by WTMs, there was no penalty ingredient in that order. And this should make us wonder, how is it that they are arriving at whatever amounts that they are arriving at? And so we said, fine, one again, okay, giving the benefit of the doubt, you say it may be because I can see you've done something wrong, and I'm going to impose a minimum penalty on you because I can't establish all of these other factors. So we said, fine. And not that we think that that is a good way for any regulator to behave, but, let's say that you want to send a signal to the market. Even if we thought that that was okay, we said, let's look at those instances where both UTIS and UPSI have been found. So these are the more serious offenses. And let's see what is it that the regulator is saying in those. And so you see that in 23 of those, penalty imposed was higher than 10 lakh. It was almost 1.88 crore. And 15J was only identified in 11 out of these 23 cases. So, if you are not identifying 15G, then you might as well just put a minimum penalty. But that is not the case. That you do have penalties which are very high, where there is no penalty ingredient that is identified. And what we also find.
What is having access to unpublished price sensitive information a problem if I'm not using it for trading securities?
We will have to write a second paper on the conceptualization of insider trading in India. And our sense is that we have gone to the extreme. In many other jurisdictions, you have to have a little more than that, but it's sort of not part of this paper. Yeah, Bhavya.
And when we're talking about UPSI, we're not just talking about having access to UPSI, but actually
Communicating.
communicating
Yeah.
with UPSI in an unauthorized fashion.
Yeah. So we're again being very
Sorry.
Yeah.
But communication of that UPSI and that was used for UTIS.
That is unnecessary.
yeah.
But communication is fine till I don't use it, right?
I agree completely.
That like I said, we have a second paper coming on the conceptualization of insider trading per se. We think that we have gone too far in the way we define this, and some of the problems come because our definitions are so far-reaching and so vague. But for this, we have sort of, we're being very careful in the way we analyze this data, because we want to sort of make sure that on every very conservative definition, these are the numbers you see. So if you start now expanding those definitions, you'll see that perhaps some of these numbers look worse. right? And then we see that non-15J factors is identified in 17 instances. Now, this comes from a Supreme Court case which said that it's not exhaustive, and you may have other factors that you might use to penalize somebody. You don't have to restrict yourself to 15G, 15J, or 15G. 15G, sorry. And 15J factors are not unique to the. So fine, the Supreme Court has said that you could use other factors, but what are those other factors that you are using, right? And so we actually manually read those cases, and we found that they are not unique to the actions of the violator. They're very like blanket statements about how this is bad for India's capital markets, or just general comments on insider trading, etc. So if you're imposing these kinds of very high penalties, the least that we could ask of the regulator is that stick to 15J, or give very clear, specific reasons that are related to the specific case that justify whatever penalties that you are imposing. So if I had to summarize the how SEBI performs on these substantial rule of law measures, you find that in 50% of the cases, that's the last line here, where either violation or connection or ingredients of penalty were not mentioned, right? And so that's a pretty, I think, bad statistic in terms of how you are faring on basic substantive rule of law indicators. We saw the procedural numbers previously. And again, like I said, this has no comment on the judgment that SEBI may be applying, because we cannot test for that judgment. And finally, if you look at timelines, it takes a long time. So if you look at the end of this UPSI period and the order, overall, it has taken about 6 years for this to get completed. Now, by the standards of, maybe by the standards of Indian courts, this is not so bad, but I'm not sure that that is the benchmark that we should be asking from our regulators. So fine, then how do these orders perform at SAT, right? Yeah, 3 more slides. We found that 32% of the orders that we have were appealed, of which 53% were allowed or remanded, which is that SEBI lost in 53% of them, and 47% were dismissed. So it's a 50-50 chance, really, that SEBI wins or loses at SAT. Now, is this too high? Is this too low? I'm not sure there is a benchmark in theory that says that, your win rate should always be higher or lower than a specific number. But having said that, 50% still seems like a rather large number for the regulator to keep losing its cases at the appellate tribunal.
But what this means is, of the orders given.
Yeah.
Of the orders given, 16% they lost.
Yeah.
Others were not appealed.
We don't know. Yeah.
No, I mean.
Yeah, they were. Yeah.
In some sense, that's the relevant statistic.
Yeah, it could be a little.
Not half.
It could be higher. Well, a lot
Sure.
of the orders.
Just from the data that you
Yes,
have,
yes,
that the relevant statistic is
yes.
that of the orders given, 16% were dismissed.
Correct. So why were they dismissed? And so we find that it was because information was not UPSI, appellant was not an insider, there was actually no communication of UPSI, there was no COC violation, and any other reason. It includes that there was a lot of delay by SEBI in initiating action. SEBI did not display application of mind, etc. Right? So most of the reasons that SAT is coming down on are really to do with application of mind. And so what we find is that things like correction not specified or 15J not being part of the order is not something that SAT is also looking down on, because we don't find that as to be the central reason why the orders are getting dismissed. So again, if we did this by total, you see that a total appeal rate for AOs was 28%, whereas order modification is where the sanction is modified, right? So the order is sort of allowed in the sense that SEBI gets to keep it. I'm using these words interchangeably now, but SEBI put a 10 lakh fine on you, SAT brings it down to 1 lakh, let's say. So that's order modification. And so you find that 56% of the AO orders that got appealed see a order modification rate, and similarly for WTMs. And again, what we find is that in certain cases, of the orders that got appealed, 100% of them saw an order modification rate when it came to certain kinds of offenses. So, for example, UTIS and others, and only UPIS and UTSI. So, we think that this is a rather high order modification rate. And again, this is conservative because, you've seen a lot of action only in recent years. And many of the cases that may have been appealed are probably still in the court, and we don't know the result of those. So we will only know the full picture a couple of years later, because that's when all the orders will become available and we'll see. So maybe this 16% number will go up a little bit more, likely because the last 5 years have been the years where a lot of orders were also passed. So we saw in previous years that the number of orders were not that high. So we'll know in the next few years how this goes. So finally, I just want to conclude by saying that, there are several gaps in SEBI's enforcement of insider trading, and these relate to both procedural and substantive rule of law measures. And analysis of SAT orders shows that there are also gaps in SEBI's application of MIND. So when you put all of this together, you think that, you begin to see that there is a problem. And this really raises question on three broad things, right? So one is the design of the regulations per se, which is that, are the definitions of insider and insider trading too vague? Is that what is causing the problem? Do we need to tighten them to give more clarity both to the regulator and to the market on what the problem is? The design of internal process manuals, maybe, the law says, for example, that you can have reasons for debarment should be written and should be specific to the case. But how do you actually arrive at that? Or how do you actually arrive at amount gain or loss avoided? And if there are no good process manuals for the regulator, then perhaps the regulator doesn't know to do these things well. And this is more a capacity and a training issue. And maybe that's one place for us to focus. So, for example, things like, show cause notice date not mentioned. That is just seems like a capacity issue. It seems like there are no templates and benchmarks for what a structure of an order should look like. And again, that's something that we are working on how to create better templates. And finally, the structure of SEBI itself. We have both the investigative wing and the enforcement wing together in one regulator that defeats the separation of powers doctrine. And, there's a huge debate in India also on whether it matters. It doesn't matter. Regulators will say it doesn't matter because, these are separate. But regulated entities who have been through these processes will say that it does matter. And of course, legal theory would support that you should not have the adjudication wing and the investigation wing sitting together within one organization where people can move between these two jobs over time. That obviously dilutes some of the legitimacy, if I may use that word, of the regulator. So that's all we have. And going forward, we want to continue working on this, on different offenses within the same regulator and different regulators. And, hopefully, we will come up with some more constructive measures on how to improve some of these orders that we are seeing. Thank you.
Yeah. Yeah.
So anyway, it's already one, so we have to close the 140. So let's take, I think 5 to 7 minutes each. We should.
We should have more questions. We normally don't leave any time for questions. Well, it's been a long time that I've looked at things to do with Indian capital markets that closely. But just first of all, some overall points. The first level at which insider trading would probably be picked up is by the stock exchanges. As you know, the stock exchanges, let's take the two major ones. There are some minor ones here and there. Let's forget about trading and exchange for commodities. But basically for stocks, it is the National Stock Exchange and the Bombay Stock Exchange. Their surveillance departments, correct me if I'm wrong, are much larger than that of SEBI. And they are the first port of call. And given the fact that they have larger numbers of personnel, they should perhaps be alerting SEBI. And it'd be interesting to know what kind of communications and whether they are telephonic, saying, we don't quite know, but we suspect this is happening. Surveillance within SEBI should be able to pick it up more. Now you look at the basic, you've used insider information, that phrase quite often, but how do you look at it in terms of a listed company? Let's forget about unlisted companies. They are not relevant for today's discussion. Listed companies, you have the board. The board has access to privileged information. Certain number of people at the management level have access to what you would call insider information. If you look at all the listed companies, the larger ones in terms of their market capitalization, the numbers of people would be very high. I think it'd be useful to put this in context as a kind of preamble to your study, that you look at it from SEBI's point of view too, not ruling out malfeasance either in the stock exchange or in SEBI or anywhere, but just the contours of the problem, because what is happening here is very interesting, because you have dived right down into the orders and how they've been arrived at and so on. But a little bit of context, because it is very difficult to find out if Mr. X in company Y told his wife something at home over dinner, and the wife decided to mention to a friend somewhere, and then it goes somewhere and somebody takes action on it. It's practically impossible to find, although the stock exchange will pick up that on the morning of such and such day, an order came from an unexpected kind of quarter for 10,000 shares of a fairly highly priced stock. So that they will suspect, but is this really insider trading? And finally, when it lands up on SEBI's desk. Now, having said that, that's the problem itself of this whole thing of insider trading. You need to define it a little bit in terms of whatever SEBI has said. I'm not saying independently define it. How has SEBI, what rules do they have for insider trading? Now, as far as penalties are concerned, I think a few high-profile cases should be part of your study in terms of the numbers. If you remember, in 2006, RIL was accused of insider trading at the level of the company itself, because RIL knew that they were going to come out with an IPO, and they are supposed to have short sold their own stock. We'll not get into the details of that case because that would be unfair, just naming one company. But in terms of the volume of what somebody gained or lost becomes important. So I just heard a comment from the floor that, it's not important just looking at the overall number in terms of how many cases SAT ruled against. But first of all, you have to see how many cases, 16% is the real number there. Similarly, in terms of insider trading, if you are going to equate insider trading, which led to an alleged gain of 10 lakhs, is very different from insider trading, which led to alleged gain of 5,000 crores. So how is SEBI dealing with these kinds of cases? Is it roughly the same kind of approach? Because as you can imagine, as the number gets larger, the kind of company and the kind of people who can influence the regulator obviously is higher. I mean, without getting into why that should be so, that's true everywhere in the world, not just here. So I think a little bit of that flavor would be useful. And the next thing I would say is that what you said about adjudication, I'm stumbling over that word, and the surveillance people, what is their background and what are their salaries? As you know very well, as I don't even know whether it's correct, the Singapore president was supposed to have remarked, if you pay peanuts, then you get monkeys. So without getting into whether that was a real comment, but the basic truth of that is SEBI's salaries and compensation profiles are very similar to other regulators, and the regulated entities and that includes the stock exchanges, even though they are the first port of call for checking on any kind of misdemeanor in our capital markets, they are paid. I mean, the NSE chairman, for instance, is paid 8 crores per annum. And that's not including other bonuses and so on. SEBI chairman is like the SBI chairman. So doesn't get, and similarly down the line. So if that is so, that has implications for how they will view insider trading and how they will. Now, you'll notice that I'm abstracting quite a bit from your work, but I think it's important to set the setting, because otherwise you can get lost in the numbers. I can understand you're using AI, you're picking up phrases and you are checking on things, but sometimes the word artificial and intelligence, and I was joking a little bit a little while back with Lavish, that it's an unfortunate word because it's giving you artificial knowledge and information. If it's artificial intelligence, by definition, it is artificial. It's not real. No. So with that's supposed to be not a serious remark. All I'm submitting is that you need to be a little careful when you're looking at picking up from the orders, whether it is the SEBI order or from the SAT order. I think a little bit more of quantification of which were the companies involved, who were the people involved, how exactly would add to the richness of the paper. That's what I will submit right now. I would like to come in at various points of time as people ask questions. I have many more thoughts, but I think let's not burden you with too many thoughts. I would submit the paper will be enriched greatly if you take a step back and give a little bit of this background. And it's not just me. Bimal Jalan, he was no longer governor of Reserve Bank of India when he was appointed chairperson of a committee to look into which are the market infrastructure institutions. And the stock exchanges were deemed to be MIIs. So the stock exchanges, don't forget them. They have a huge role in this whole thing, not just insider trading, any kind of malfeasance in the stock market. And to that extent, Dr. Jalan's committee suggested that these stock exchanges should not be listed. And now you will say that, why have you brought in all that? Very important. If you do not have the people who are engaged on a daily basis on checking on this, if they have a vested interest in their stock prices going up, it's not the healthiest of things. So when you're looking at the capital markets as a whole, the first port of call, according to me, is the stock exchanges, and then SEBI. Of course, SEBI has the final authority, and then above that is SAT. And my very able research analyst, Alia, has pulled out a lot of numbers in terms of the cases where SAT has dismissed whatever SEBI has said. So have you pointed that out. And it's not quite clear by looking at the numbers what is the underlying rationale of SAT. And one thing which comes to my mind, because I was looking at it in the context of the Insolvency and Bankruptcy Code, just like our NCLATs are understaffed, SAT seems to be hugely understaffed. So I don't even know, you are of course commenting based on AI, what orders of SAT, but I think SAT itself needs, just like as you pointed out, SEBI needs to improve on the way it looks at insider trading and the conclusions it derives. What about SAT? Just because SAT has set aside or reduced the penalty imposed by SEBI, how comfortable are we and confident are we? Is it because the number of judges there? And I think they have just one bench in Mumbai. Do they have any benches anywhere else in the country? Only one bench. And we just talked about what all is going on. Our capital markets are small compared to the NYSE, but it's not that small in an absolute sense. So one bench and 4 or 5 people on that bench. I don't quite know how many. And somebody is ill, somebody is close relative is ill. I don't quite know what we are getting here. I'm sensing from my sort of somewhat couple of steps removed from capital markets now, then there are huge areas of gaps and lacuna which have to do with administrative, I would say, lapses on the part of the government. Because as you know, SEBI board members are appointed by government. And the SEBI appoints its executive directors. In times of yore, it would be useful to also know what is their competence as far as insider trading is concerned. How well are they trained? How well, what background did they have? Insider trading is a very, very difficult thing to actually put your finger on. So with those general comments, because I'm really not competent to comment in any great length with regard to your study, I feel that it's a very useful study because it's asking us to think afresh as to, you just get some orders. What are these orders based on? How often have they been thought out? How often have they been reduced, the penalty that is, or set aside by SAT? I think this is very useful work. But all I would submit is that perhaps a little more of a deep dive is required, and then also take a step back. This sounds contradictory, but it's not. Take a step back, look at the whole picture, and then dive a little more into the numbers that you already have researched and brought out in your paper. Thank you so much.
Okay, I'll just. Sorry.
Yeah.
Sorry.
No, that's all right.
Yeah, thank you very much for this wonderful presentation. And I've gone through this study. Of course, I got it very late as he. So I have not come across any other study like this. You have gone into the actually raw data, which are very difficult to clear. Of course, you are used to this artificial intelligence, and of course also done manual scrutiny. But this kind of work really I had not seen it earlier. So I want to compliment you and your other co-authors. But before I come to the specific comments of this study, I just want to make two observations. One is about the general observation about the insider trading. It's very difficult to define, howsoever you may define it. There will be some gaps. That's number one. If it is hard to define, it's harder to even detect and then prosecute the people who are involved in in insider trading. We know the case of Rajat Gupta and Raj Ratnam. There was, I think they were prosecuted only because the Securities and Exchange Commission could get the taped conversation between them. Otherwise, perhaps they might not have been convicted. And if you know that, of course, I'm sure you know the story. Within 1 minute of after the conversation was over, a large number of orders were placed in the market. That's how they could catch. That's number one. And number two, there's a lot of data in your paper, but I think some places there is a lot of confusion about the number of orders and the number of cases. So I think everywhere, whichever table you use, I think it's very important to mention, like, are we talking about the number of orders or the number of cases? Because when I try to match somewhere, I couldn't do that. And number three, whatever data you have presented, you have given somewhere percentages. I think it's also important to give also the absolute cases so that people could match those numbers. I'm not saying there's any problem with the data, but it makes that analysis a little easier. So having this thing made two general observation, let me come to the 3 points on which you have researched. One, I don't know, you said you have data from 2003 to 2023. But the graphs and other data which you have shown, they're based only from 2011 onwards, if I'm not wrong. I don't understand why is it so. Couldn't you collect data for the earlier period? I'm not really clear, number one. And there is a lot of data which you have presented in table 1 to 4 in your first part. But it's very important that we divide these data into sub-periods and see whether there are some patterns, what patterns are remaining the same, what patterns are changing. Otherwise, based on just those data, I'm not able to make out anything, whether it's good or bad. So, And of course, I know that there are other, quasi judicial bodies, and their nature of work is different. I would like even you to look into their orders. Of course,
We're doing
it
one
itself
of
is
it.
very, very tough exercise to look into their orders and see whether we can, where the SEBI stands vis-a-vis those regulators. And now come to the second question. It's a very serious matter that your study clearly points out that in many cases, no, SEBI doesn't follow it's a quasi-judicial body, but it doesn't follow the, rule of law. It doesn't mention the show cause notice date or the order when it was passed last. But I'm wondering, what is the remedy for this? Is it not possible to go to some, again, SAT and then get them redress, or you people write some op-eds in the newspaper, bring it to the notice of the public so that there is some impact on those people who are writing those orders? It's a serious issue, so that they can take care of that. That's number two. No, the most important part of your study is about the where this where these orders which the SEBI passes stand at the security appellate tribunals. So I would say that whatever numbers you have presented, again, I have some confusion, but I'm taking that you had 333 orders, and you could match only 119. But the number which you're mentioning when you're giving the presentation, I think you mentioned something 200 or so. I don't know whether which is the right number again. So technically, it's only some, how many percentage of cases which were appealed? I think it's 30% or so. And the orders were modified only in 16% of the, half of the cases, 56%. So 56%. So only half of the cases orders are modified. So again, I'm not too sure whether this is high or low. So in this context, it's very important that you dig out the records of other regulators in other countries, particularly for this aspect, to see how SEBI is performing vis-a-vis, other regulators. That's number one. Number two, SEBI also doesn't, and while doing so, you need to keep in mind that SEBI doesn't have full investigating powers like other regulators have. As I mentioned, the case of Securities and Exchange Commission, SEBI got the powers to recall the conversation records from the telecommunication companies only in 2013. Before that, they didn't have that power. Now they're asking for power to record to intercept the conversation. But that power, I'm not too sure whether it will come or not. Vishwanathan committee had recommended that power to be given to SEBI, but that has not happened so far. So it's very important that we keep in mind these, restrictions which SEBI has, and then look into whether it is performing well or not. Number two, SEBI also has it's a young organization. It was set up only in 1992. See, almost 60 years after the Securities and Exchange Commission was set up in 1934. And for many years, it didn't have its own staff. I know I was working in the capital market division in the Reserve Bank of India. Of course, then only I interacted with Jaimini ji. So for many years, it didn't have their own staff. Even their, I think it was only after 10 years or so, they started recruiting their own staff. So it takes time to develop expertise. So it would be not fair to compare the performance of SEBI, even with other regulators when you are doing, when you realize that this is much younger institution. One last point about the, you mentioned about this penalty. I have not, again, there are two numbers which are very, very difficult to reconcile. I couldn't do that. And to the best of my knowledge, SEBI has never imposed that kind of penalty. You have mentioned that under the power of the SEBI is to have to impose penalty of rupees 25 crore maximum and 3 times if the amount involved is higher. You have mentioned that average monetary sanction is rupees 45 crore in 52 cases.
That's disgorgement.
That's but is that different? Like, is that not that taken into account? That also I had confusion. That's separate. So what is the maximum amount of penalty which SEBI has ever imposed on anybody?
What is our number?
Do we know that number?
Yeah, we'll have a number in our data.
So because number which I came across was only something like 60 lakh.
No, it will be more than that.
Okay, so I think we need to
Yeah.
check that.
Yeah.
And so my point is that SEBI has been rather soft on insider traders, if you ask me. Because it has not levied many, and your own studies suggest that it has, most of the cases, it has levied only rupees
10 lakh.
10 lakh. And SEBI has also not taken anybody to the court for criminal proceedings, and whereby it could get some, persons prosecuted and imprisoned. So I would say SEBI has been rather, lax on insider traders, and we know that insider trading is rampant, not only in India, everywhere else. Only 15% of the cases are, detected and then prosecuted. So I would feel that we should be little careful in this. One, of course, I said my last question. There is one more, SEBI has not been able to take anybody to the court and get convicted. That's a separate issue. You make the last suggestion about the separation of powers. So it's a very difficult thing to do. Again, you need basically two regulators, one with the investigation, one with the enforcement. Do we want to create another agency?
No, you
I
could
think
just-
so long as you have two separate departments undertaking those two activities, and they are under two different whole-time members, that's fine. And in any case, I think let's also investigate what is the practice, what's the global best practice in this regard. We had to create new infrastructure is not so easy, and it entails some cost. Of course, one last thing which I again want to mention, that role of whistleblower. SEBI has put in place now a system of whistleblowers, whereby if somebody gives the information to SEBI, SEBI will be then able to revive it if it's able to prosecute the wrongdoers. I think that should help the matters. I will close here, and thank you very much again for this wonderful study here. Thank you. Oh, sorry. Yeah, I think we can open the floor for question. Yeah. Yes, Sharad.
Yeah, this is seeking thoughts from Bhagwati sir. Sir, NSE as such or BSE as such, I mean, their revenues are basically on the number of transactions as number of shares sold and all that. So considering that insider trading, if it happens or not, I mean, they're going to get volumes revenue. A. B is also that because and NSE also got into this recent, I mean, I think in the past also that whole they got mingled with, I mean, it's SEBI just came out with an order for them also. They got mingled with some faster frequency guys and try to do
Co-location case.
yes, co-location case. The last thing which you rightly pointed out with Bimal Jalan sir also pointing out. Do you and NSE is also planning to get into now IPO? That's what they have actually sought SEBI's permission. So I'm just curious to know your thoughts on this.
Well,
whether they should even get into that, that whole, you said, your thoughts were like they should get into.
I think it's absolutely beyond belief that BSE was allowed to go ahead with an IPO and NSE should not do it. But who am I? These are my personal views. I've written about it at various places. But the sense I get from your comment and question is that you also feel that is not a good idea. The problem is that NSE is not just owned, it was set up, as you know, by LIC, SBI, etc. All these institutions have been set up by us, taxpayers, because the institutions like LIC still, even though it's done an IPO, it's still majority owned by government. So a little amount of money has come into NSE from some foreign sources. So they are pushing very hard for an IPO because they then feel that it will be easier for them to exit if they so wish. But that is a fact. If you are traded on a stock exchange, it is much easier to sell your stock than if you are not traded on a stock exchange. Then you have to look for people on your own. So I would say that at some stage, wisdom should dawn on government and it should request BSE to reverse It's not an easy thing to do because there are a whole bunch of shareholders of BSE now, but I'm sure there are ways in which it can be done which will not roil the markets. But the thrust of your comment/question, I agree with, that it's not a good idea to ask stock exchanges. It's just not possible for a regulator to know the nitty-gritty of equity markets, which even in India are huge now. Okay, you can say that there's about 500 stocks which are trading with any great volume. The rest are these so-called penny stocks. And in fact, sometimes you have to be more careful with the smaller stocks because it's easier to corral and jack up its price. And some unsuspecting person might say, my God, it's gone up by 25% in the last 2 days, and people are telling me it'll go up another 25%. Of course, that person doesn't have that much money, puts in a crore or something and loses most of it in the process. Then those cases become somewhat more obvious. But more generally, when this company is very large, it's very difficult to find out. I will not mention the name of a company, but it provides inputs into tire companies. And you can try and figure out which company that is. And there's a lot of insider trading with regard to that company. And to the best of my knowledge, it has never been pulled up. So is it stemming from the management itself? Is it shareholders who come to know somehow? Or is it from the board? Who knows? I'll stop. I've spoken long.
No, one small request. I think let's confine our question only to the Dr. Jaimini Bhagwati and me are always there. We can take another session for you people.
Good
No
point.
problem. Yeah. So yeah, Karthik, just confine yourself to the study and please ask questions if you can to the author, main author, and of course they are co-authors also. Yeah.
Everything is related to this study. There were 3 clarifications/comments. Thank you for presenting the extensive study to us. First is on the quality of the order. Do you think that there is a role played by how there are judicial and non-judicial members usually at tribunals, and the quality of order differs when you look at non-judicial members writing these orders that look at it as just passing a concluding remark on the proceedings rather than capturing everything that's happened in the proceeding? Secondly, what would be the underlying message you think the study is trying to put out? That is, say, has the kind of intervention that SEBI is doing impacted the manner in which insider trading is happening in India? That is, has it reduced, has it increased, or has it become harder to regulate? Thirdly, on the limitations of this study, do you feel there are parts of the written law that itself in the main act, in the parent act itself, that's a concern because of which the manner of SEBI's working is something that cannot be changed until the parent act is changed? And also on the capacity of the team, in sense, did they have court observers? Were there people who could go and sit in the court and see how the proceedings were going as well?
Yeah, thanks. No, there were no, I mean, in our study, there were no court observers. We did not go and sit and see what was happening at SAT. We read the orders. In terms of, the main message of the study, I think, is just to point out that there is something that is broken. Now, you may argue on with this 16%, it's too much, it's too little, but or relative to some other regulator in India, it's too much or too little. But if you just look at the, the basic facts of a case, idea that a penalty amount should be proportional to the crime, there are fundamental things like these that are missing in these orders. And so I think the point that we want to make is that there is something that is going wrong and we need to address that. And that brings, your second question on the law itself or the training that why is it like this? So partly I think it's because the law itself is weak. So when you define insider in such a broad manner, it's much easier to bring out these cases. And somehow it's, there's a whole literature in economics, for example, on whether insider trading should even be a crime or not, right? And there are things to be said on both sides, that whether it should be or it shouldn't be. And if the literature is so divided, then perhaps one approach that you may take, given limited state capacity as well, is that you have very narrow definitions of what is insider trading and you go after them, because there you are actually able to fulfill the mandate of the law in terms of how you are prosecuting. So I think we do need to relook at how insider and insider trading is defined in the law, because as you saw in our data set also, it's in the last 5 years that you see a lot of these cases going up, and then that's where some of these problems start to arise. On the question of the judicial and the non-judicial member, I think, we haven't studied SAT, and I take Dr. Bhagwati's point as well, that it's true. How do you know that SAT is the beacon of anything, right? But it's an appellate tribunal, and you want to test how SEBI is doing at an appellate tribunal. What are the problems in the functioning of an appellate tribunal per se? That's a separate study. And we expect that there will be issues of a judicial versus non-judicial member and quality of orders. We've studied APTEL in much more detail, I think, and we do find some issues there. I think Bhavin can.
Yes, I just want to add in one anecdote. While it's important to keep in mind that SEBI itself does not have judicial members, of course, the SAT does. But there's an electricity regulator in each state, each of which typically is mandated to have a legal member who is often a judge. And we've seen this in the case of Telangana. When we looked at their ERC orders, there was a particular patch when no legal member was present. That patch of years overlaps with the time period in which most of the orders were overturned at the APTEL for basic procedural rule of law violations. So if nothing else, at least from that study, one can say that some formal legal training ensures that you write orders that at least comply with the procedural rule of law requirements.
And finally, on the training, I think what is really required, see, one is, where is the pressure going to come from, right? It's either going to come from the top, because the Ministry of Finance is asking the regulator to write orders in a particular way, or it's going to come because there's a lot of noise from the bottom, right? Regulated entities are screaming, or researchers like us are beginning to shine light on what is going wrong. And so, the question is, where will the incentives for better training come from? And I think there's a case to be made that the kind of things that Bhavin said, or some of the things that we find are very easily solvable. They don't have to do with the law, the vague law, and it being difficult to find and whether it should exist or not. Those things can certainly be fixed if you invested in capacity building within the regulator. And somewhere, the fact that there is an overturn rate against you should matter for something. If it doesn't matter, then as a person, my incentive is, so what? It got overturned. What difference does it make? Right. So again, that goes on to the performance incentives of the overall regulator. And again, you have to think about what the incentive of the frontline staff is to get this right in a specific manner.
Yes, sir. Dr. Mohana.
Thank you. First of all, I learned a great deal. I studied it. Amazing. This is the kind of work that one likes to see in terms of really getting into the data and, getting a story out, seeing what's happening. And it takes a lot of hard work. So compliments to you and all your co-authors. My comments are sort of in line with what, in part, Jaimini and Janak Raj said. One, need to step. I will ask the question of so what. Okay. So the first thing is, need to get a sense, is insider trading as a problem important? One needs to get a sense, is it really a problem? Is it minor? Right? Second, how does it compare in terms of importance in India relative to other stock markets? Is it more there? Is it more here? And so on. I think just to get a sense of what is it that we are talking about. In a similar vein, in terms of the definitions of insider trading, are other insider trading definitions better or worse than ours? Are they more precise? And the question, I think, that one of you raised, I think, that can they be more precise? Because it is a very slippery concept, as everyone has said. So I think that those kind of things one needs to think about a little more, just for us to understand what is it that we're talking about. Is it a general problem in the world, definition, or it's not?
Yeah.
Well, let me just finish before I lose my train of thought. And yes, I would be ready to answers. Also, the fact that you mentioned that the cases have gone up tremendously in the last few years. Question arises, is it because there's been some pressure from somewhere? Is it because staff is increased? Is it because Indian stock market players have become more corrupt? Right? So I think that when you see this kind of huge increase that you've shown, you wonder, what's going on? Is it that we were sleeping earlier? Right? So I think that these kind of questions, and also, of course, what I learn a lot from what you've said, both in some of your comments now and then when you present the paper, is a huge issue of state capacity or the regulator capacity. Janak Raj talked about it being a young organization. I was on the board briefly for a year and a half, 2001, 2. Basically, I was his shadow on the board, actually, because he knew the stuff I didn't. So I just went and mouthed whatever he said in the board. But it was clear, this 2001, 2, the organization was not competent at all. Okay. And then finally, just what Janak Raj has said on separating the enforcement and the investigation. Now, that's a general problem in India. In some other places, for example, here the police is both the investigator and the enforcer. Okay. Now, they don't even have separate departments for that. So I think that what Janak Raj said is important, that there's nothing wrong in my view also in that SEBI being both the enforcer and the investigator, but within SEBI, there should be a difference in the departments.
So two responses. One is on the definition of an insider. We've done some international comparisons and we find that our definition is far more expansive than other jurisdictions, where in other jurisdictions you need to have just communication of UPSI, for example, or having access to UPSI is not enough. There has to be a little bit more. So in the early days, it was that you needed a fiduciary responsibility because otherwise what duty do you owe to the other shareholders? But that has been expanded over time in all jurisdictions, but it has not gone as far as we've gone in India. And, we are actually preparing a separate paper on just the policy thinking behind insider trading. So that point is very well taken. Yeah, in terms of separation, I think this is a long-standing, in theory, it may be that, okay, they are separate. But the question is, whenever, even if they're separate departments, but if they're housed in an organization, does it really work? Can we make that happen? And the answer to that is, I think, not clear. And if you look at the recent developments in the US as well, the courts are coming down heavily on regulators passing fines or writing legislation that was not initially intended in the law. So the regulations kind of going outside the scope of what the law said, or the penalties going outside the scope of what they could do. And the US Supreme Court is insisting that you go to courts for everything. Now, the minute you start saying that in India, we realize what our problem is, right? You don't want everything to go to Bombay High Court, because then there are infinitely many other problems that will come because of our court capacity. So it's a difficult problem to solve. But at least from conversations, for example, we see that people get appointed on both sides. You're in, one, at least do that much. You're in one department and then tomorrow you go into the other department. You're friends with the judges, the quasi judges. And I think that there is a issue there, which we need to address a lot more within our regulators.
Okay, please. Yeah.
I think.
Yeah, okay, yeah.
Good afternoon. My question is related to, you have studied the decisions of SEBI to the SAT. There must be some cases which have in appeal from SAT to High Court as well as Supreme Court. So,
Go to High Court, no? SAT has to go to
Supreme Court in that case, if it's the next level of, in fact, appeal. So what is, in fact, were you able to track, in fact, what is the decision of Supreme Court?
We haven't gone to that level. That's the next step.
That will, in fact, tell you what is the quality of, in fact, investigation and decision which has been done by SEBI and SAT.
Yes, I agree.
So that will be the major, in fact, impact of your study. If you can just look into that. Second thing is that you mentioned that investigation, SEBI as well as stock exchanges, by law, they are supposed to have the information from the FIU, Financial Intelligence Unit, which in fact, all the high value transactions have to be reported mandatorily. So information is there. What they are doing with the information, that's a big question of whether SEBI or for that matter, your stock exchanges.
Yeah, so we don't study the exchanges at all because
So
exchanges, yeah.
SEBI also has got
Yeah.
power, when high value transaction has to be reported. Thank you.
Yeah, yes,
We have short of time. I'll just read off 3-4 points.
Sure.
And then we can talk about those data. First, absolutely. I mean, I being a data guy, I mean, I thought it was fascinating what you did. I know the difficulties, but it's really, very interesting. What have you got from this? The way I see it, first, you need to get the hygiene right. The orders need to be clean. Second, you need to reduce the delays. That's all. Everything else is handling. Right? So there is no need for you to now to start thinking about what kind of a regulatory setup you need, because you're not getting that from this data.
Yeah.
Right?
Yeah.
So I would say just stick to that.
Okay.
That itself is contribution enough.
Okay.
Including the definitional issue. We all know the difficulties with definitional and the need for insider trading laws and so on. So I would say avoid it, just stick to basically what you have here. I would definitely ask you to look at what happened in 2017. It's an ideal case for an event study. Something happened in 2017. It could be that your law of 2015 was notified by 2017 or something like that has happened.
Sure.
And there you'll find something really interesting. Though the issues that you looked for were exactly the same, there was something else that happened which was pushing this. So I think there's something really interesting which you may have, which you may get. Last point, in this kind of work, it's best to use the case study approach. Go talk to some people there.
We've done.
Then you must have it here,
Yeah.
because a lot of the issues will get clarified
Yeah.
from those conversations. And it's okay to have conversations in microeconometric studies such as this. So I think it would really benefit.
Yeah, we've done multiple conversations with various stakeholders. But we didn't want to
But
put,
you can,
yeah.
you can, and in fact, it makes for very rich studies.
Yeah, absolutely, absolutely.
That you just said it. What is the sense of from this, what kind of insider tradings are really been a problem?
Sure.
Last one, we have already overshot the time. One last question.
I just wanted to know, you said you used LLM models, right? Did you do that in-house? What was the cost and time implication of that?
Tomorrow there's a
And,
full talk for 1 hour on exactly what we did, who we partnered with, and the comparison of time and cost between manual sort of, human reading and AI plus human reading. So I think we'll answer those questions tomorrow, but happy to talk to you separately and give you the full information. Yeah.
Okay, with this we close. Thank you very much for all
Thank you
participants.
everybody for your comments. It'll really, when we do a round 2 of the paper, we'll incorporate all these comments. And so before we release it, so we haven't released this paper yet because, we were hoping for good comments like this to improve the quality of our work. Thank you.
Thank you.
Thank you very much.